This copyrighted video was produced by the California Department of Rehabilitation and is intended solely for educational purposes.
Up next on Employment Today, we're going to delve into the subject of reasonable accommodation. And here to answer some of your questions is disability consultant and trainer Ed Flores. Hi, Ed. Welcome to the show.
Hi, good to be here.
So why don't you please tell us a little bit about your background in reasonable accommodation?
Well, I've been working for decades with employers, managers, and supervisors to help them understand their rights and responsibilities under the Americans with Disabilities Act and California's Fair Employment and Housing Act, also known as the ADA and FEHA.
Well, great. This seems to be a popular subject because we have a number of people lining up on our question cam to get more information from our expert. But before we get to the questions, it's probably a good idea to define our terms. So let's start with the basics. What is reasonable accommodation?
Reasonable accommodation is any change or modification that will allow an employee with a disability to perform the essential functions of their job.
All right then. Who has our first question?
When do I need to provide a reasonable accommodation?
Ed?
Okay, there are three situations where reasonable accommodation may be needed. The first situation is during the job interview or hiring process. In this case, an employer may need to modify the process so that everyone, including people with disabilities, are able to apply and interview for job openings. Secondly, employers may also need to provide an accommodation in order to help someone perform the essential functions of their job by making small changes to their workstation. Examples here may be acquiring a piece of equipment or modifying a policy. And third would be accommodating someone so that they can receive the same benefits and privileges that other employees might enjoy. For example, an employer might need to make small changes to the lunchroom, such as lowering the microwave oven or raising the table, if one of their employees was unable to reach or use these items due to mobility or other physical reasons. These small changes would enable the employee to eat lunch with everyone else.
Wow, I never thought of that. What other kinds of accommodations are we talking about?
Accommodations might include job restructuring, modifying work schedules, or other small changes. Any solution that is agreed upon by the employee and the employer to solve a work-related problem.
All right. Well, let's get to our next question.
So who sets the rule? Is there some governing body for this process?
I'm guessing we don't let employers make up the rules as they go along.
No, we don't. The EEOC, which is the Equal Employment Opportunity Commission, has guidelines that outline steps that employers and employees should follow to comply with the ADA requirements.
Who's got our next question?
What happens if one of the parties involved does not want to participate?
Good question. Ed?
Well, both parties have to be involved and demonstrate a good faith effort.
What exactly do you mean by good faith effort?
Well, there are legal guidelines used in determining good faith interactive process. They involve working with the individual to determine his or her precise limitations, how these limitations affect job performance, and identifying solutions that might work best. Both the employer and the employee must communicate directly with each other, and neither party can delay or interfere with the process.
Now, when does the reasonable accommodation process have to begin?
The process begins once the employee brings the need to the employer's attention or when the employer becomes aware of the need.
Let's hear our next question.
Does an employer have to grant every request for reasonable accommodation?
No, the ADA and California's FEHA provide guidelines for employers to use to determine if a request would impose an undue hardship. An employer would not be required to provide an accommodation if, after making a case-by-case assessment, they determined doing so would be too extensive, disruptive, unduly costly, or it would fundamentally alter the nature of the business operation.
What are some of the other situations where the employer may not need to provide an accommodation?
If the accommodation is not effective, or if it causes a danger in the workplace or conflicts with other laws.
Well, this has all been great information. Anything else you'd like to add?
Well, I think it's important for us to add that reasonable accommodation is good business and usually very inexpensive.
Well, thank you, Ed, for walking us through the ins and outs of providing a reasonable accommodation. If someone wanted more information, where would they go?
They should visit the Department of Rehabilitation's website at www.dor.gov disabilityinfo.ca.gov and click on the Disability Info tab.
Hey folks, could we please have a big hand to disability consultant and trainer Ed Flores.
Thank you.